Good afternoon. Can everybody hear me? Yes? Perfect. Hi everyone. As Yasmin said, there are thunderstorms due here this afternoon. You've probably got them your end as well, but I've had a couple of power cuts over the last couple of days with these storms. So if you lose me for a bit, I'll come back as quickly as I can. So let's get started. Let's talk about what's happening now with the furlough scheme. I'm not sure if you've had a chance to have a look at some of the information that's out there, but in all honesty, it's a lot more complicated, I think, than when we started off with the initial furlough scheme. Probably not helped by the fact that the government, as a way of updating the guidance rather than issuing new guidance, which is what it's done previously, it's updated the current guidance, so you have to sift through and find out what the changes are. And secondly, it's issued some new guidance. And for those of you who are trying to get ahead of the game, I'm pretty certain you might have had a look at the examples and things on the website for the government with respect to calculations, and they're a little bit of a head fry, there's no doubt about it. So let's see if we can pick through this today and make it a little bit more straightforward. Starting off with, obviously, when we had the webinar, I think it was last week, we were talking about the fact that there was a cut-off date of the 10th of June. And that was a cut-off date for anybody to be newly furloughed that hadn't been furloughed before. So now, as of the 17th of June, it's no longer possible to add any new entrants to the revised furlough scheme. So you're out of time, and if you haven't furloughed employees before, you don't get to take part in the new scheme. So only also employees who've been furloughed for 3 weeks before the 13th of June can continue to be part of the scheme after the 1st of July. So employees don't need to be on furlough on the 30th of June. So I think these are some of the questions that I've been getting from clients. They're asking, okay, well, if that's the case, does the employee actually have to be on furlough on the 30th of June? And they don't. They have to have been furloughed before, but they can actually be at work on the 30th of June to still be able to take part in the extended scheme from the 1st of July. The number of employees that you can claim for after the 1st of July cannot exceed the maximum that you claimed for in the previous scheme. So that means, for example, if you claimed for 20 employees in May and then you claimed for 40 in June, from July onwards, the maximum you'd be able to claim for would be 40. So just bear that in mind. Now, there was one exception to allowing these new entrants into the scheme, and I think this is a really positive development. So the government have said that if you've got anybody that's returning from maternity leave or any other family leave, so it would be shared parental leave, for example, they're not prevented from accessing the new scheme. So let's say mid-July, you've got somebody that comes back from maternity leave. They can be furloughed for the first time under the scheme, and obviously in accordance with how the scheme will now change through July until October. So that's a really positive step. So if you've got anybody that falls into that camp, they get to come back and they can be furloughed. So what about making a claim? Have there been any changes to that? So any claim in respect of furlough before the 30th of June has got to be submitted before the 31st of July. So that's a really key date to make sure that you've got recorded, because you're going to miss out on making a claim for anything up to the 30th of June if you haven't made that claim by the 31st of July. After the 1st of July, there's a change as well. So a claim must start and end within the same calendar month. Now, the reason that they've done that is obviously because going forward, there's going to be changes each month with the way that the scheme is administered. So it has to be done on a monthly basis. It's possible to make more than one claim, though, per month, but each claim has got to be for a minimum period of 7 days. So you could ostensibly have 4 claims in a month if you've got the opportunity to do 4 7s, which is 28. The only exception to the 7-day claim is if you're claiming for a few days, which are at the beginning or at the end of the month. So, for example, if you pay weekly and the month then results in a week being split across two months, in that case, you'll need to make 2 claims, 1 for each month. So how will this flexible furlough work? The first thing, and I know this is one of the questions that I've had, it was somebody actually asking about whether you could furlough for 2 weeks and then bring somebody back for 2 weeks. The important thing to note from this is that any sort of working pattern is permitted. So the employer can basically say, I want you to come and do this couple of days, then I want to furlough you for 3. The next week, they might say, I want you to effectively work 4 days, but you're furloughed for 1. anything goes effectively in terms of the working pattern that can apply. The good thing about that then means that there's no restriction or minimum period on the amount of furlough that can be taken. So, for example, previously it was a 3-week period for furlough as a minimum. That's been removed and any pattern will apply. Now, obviously, if you're moving from the current furlough scheme into the flexible furlough scheme, you'll need to think about notifying your staff and getting some form of agreement like we did previously with respect to furlough. So it could be, as we know now, because the government produced clarification on this point, that we don't actually have to get the employee to sign to say they agree. But nonetheless, you want in writing confirmation that the employee's been notified that you're moving towards a flexible furlough arrangement. And it might be that you are going to completely set out how that's going to work, or it could be that's going to vary. And in either case, that notification should really set out what's going to happen and how that furlough scheme is going to be applied going forward from the 1st of July. You'll need to think about, because obviously if it's changing in terms of the working pattern with the employee coming back and perhaps doing 2 out of 5 days, for example, you need to start thinking about what the rules are going to be on the days that the employee is not working. So this comes back to right back at the beginning when we talked about the contract of employment. So is there anything under the contract that says that the employee cannot work for a third party whilst they're employed by you? So you might want to be strict about that and say, well, on the days that you're not working for us and you're furloughed, you remain employed by us, and under your contracts, you're not allowed to go and work for anybody else. There have been some employers, of course, and it's been permitted under the scheme that in any days that anybody's furloughed, they can work for a third party. So again, you'll need to think about if there's been that type of arrangement in place, whether or not you're going to allow that going forward. And again, that needs to be conveyed to the employee so it's clear what the terms and conditions are that are going to apply. Now, there's a change in terms of record keeping with this flexible furlough scheme, and where it's being used, you've got some additional requirements. So you will be required to retain for 6 years records of the usual hours, and we'll look at what usual hours are. When we did the webinar last time, we had no guidance really around what that was. We'll look at that in a little bit, but you need to keep a 6-year record of what the employee's usual hours worked are, including details of the calculations, so how you've come to that number. You also need to keep a 6-year record of the actual hours worked for this period, obviously during furlough. Now, you need to remember as well that this flexible furlough is not compulsory. So it remains the case that if you're still being severely affected by COVID and there is no work for the employees to carry out and you do not require them to come back to work, that they can remain on furlough until the 31st of October. And we discussed this in the last webinar, and it is the case, therefore, that throughout July, there is no change. So effectively, during July, you can fully furlough somebody. There's no, you don't have to top up. The 80% still applies, and it includes the NICs and the pension, the employers' NICs and pensions. August, there's a change. So from the 1st of August onwards, you will need to be responsible for the employers' NICs and any pension payments. That's the same for September, but in addition, a 10% contribution to the 80% cap. And the same again for October, but with a 20% contribution. So as we go through the next few months of the furlough scheme, it sees the company having an obligation to contribute more to what the employee's entitlement is under the scheme. We ought to think about how we calculate furlough now with this flexible scheme, which is probably the area that everybody's really quite frightened of and thinking, I don't understand this at all. The guidance is really quite complex, which sets out the rules about how the amount of grant that you're going to claim for under the flexible scheme should be calculated. I'm not going to go through the examples that are on the government's website, but I would suggest that you have a look at them if you haven't had a look at them already, because the key thing here is that you need to start thinking about it now and trying to work out those calculations, especially if you've got large numbers on furlough that you're going to start to bring back part-time. In each case, you're required to calculate a baseline number of usual hours, and I referred to that, didn't I? So in order to do that, it will be based on the calculation that you previously used for employees to make a claim. So for those with fixed hours, if you remember, it'll be the hours that the employee was contracted for at the end of the last pay period prior to the 19th of March 2020. For variable hours, it'll be either the wages from the corresponding pay period last year or the average pay for the tax year 1920, whichever is the higher. And remember, that's up to you, and whichever is more beneficial to the employee. So if the employee is contracted for a fixed number of hours and their pay does not vary according to the hours that they work, you need to start with the hours that the employee was contracted for at the end of that last pay period, ending on or before the 19th of March 2020. Divide that by the number of calendar days in the repeating work pattern, including non-working days. So if that's a full-timer, that's going to be 7 days. And the number will be 7 that you divide it by. You then multiply that by the number of calendar days in the pay period or the partial pay period that you're seeking to claim for. And then it has to be rounded up to a whole number if it's not a whole number. The guidance states then that if you have any employee with fixed hours who was on annual leave or sick leave or family leave at any time during the last pay period on or before the 19th of March, the usual hours should be calculated as if the employee had not taken that leave. And hopefully that sounds a bit clearer perhaps than what people might be thinking the explanation is. Now then, where the pay varies by the amount of time worked, then you're therefore likely to have records for the number of hours worked. So if you looked back on the pay slip for April 19, that should give you effectively what the amount would be if you want to use that as your guide for calculating variable hours. But the usual hours will be calculated based on the higher of either the average number of hours worked in the tax year 1920 or the corresponding calendar period in that tax year. And as I said, you could look on the pay slip to find that out. So you need to calculate the number of hours for each pay period or part of the pay period that falls within the period that you are claiming for. When you calculate the usual hours, you'll need to include any hours of leave for which the employee was paid their full contracted rate, or any hours worked as overtime, but only if it's not discretionary overtime. So start with the number of hours worked, including paid leave in the tax year 1920 before the employee was furloughed, or the end of the tax year if it was earlier. Divide it by the number of calendar days the employee was employed by you in the tax year 1920, up until the day before they were furloughed, or the end of the tax year if that was earlier. Multiply it by the number of calendar days in the pay period you're claiming for, and again round it up to the next whole number. If everybody hasn't glazed over after me going through that, I think it would be a miracle, quite frankly. So how can we reduce this complexity? What can we do to make things easier? Somebody had asked me the question before this presentation, can you do 2 weekly rotations with furlough and then back in the workplace? For me, looking at this, one of the easiest things you'd be able to do is to do block working and block furlough, mainly because if you're getting people to come in part days and then some days when they should be full time rather than all days, I think that the calculation probably will be a little bit more of a nightmare than if you were to do block work and block furlough. And what do we need to do in terms of next steps now through all of this? So if you're continuing to furlough or full furlough people, review the existing arrangement and see if further agreement needs to be reached, or you need to notify the staff what your intentions are with their continued furlough. Especially consider, does the employee need to be notified if you're going to extend the furlough period? For example, I've already worked with some clients who are issuing letters to say, you will be furloughed until the end of October, and this is what will happen during that period. If you're going to invoke flexible working, again, you need to be notifying the employee in writing that that's your intention and how that's going to work. If you're currently topping up, which we know you're not obliged to, and you realise that going forward that's something that you may not be able to afford, then you might need to address that in any notifications to the employees who may already have had top-ups previously. If you've got employees returning to work, then we really need to work hard, do those risk assessments and reassure any employees about returning to work and that it's a safe environment for them. Start thinking about these calculations for flexible furlough now. Have a go, see if you can have a go at the calculations and work out, because obviously if you've only got a few employees, that might not be a massively onerous task. If you've got large numbers of employees that are furloughed, you could be looking at a real task in trying to do this. Have a look at your record keeping procedures. Okay, we know they're changing under flexible furlough, so have a look at what you've got in place and look at what you should be doing now going forward so that you're ready for the 1st of July. And ultimately, my main concern is that these this new guidance and these calculations are so complex that unfortunately it might put some employers off actually introducing the flexible furlough scheme just for those reasons, which means it may bring forward your thoughts and your views and your need to think about redundancies and obviously how that's going to work then going forward and what steps you need to take to implement that. Remembering, of course, that because an employee is furloughed, it does not mean that you cannot require them to take part in a redundancy procedure and, of course, make them redundant. I'm just going to move on now to the couple of questions that we had come through. If you just bear with me a second. So the first question that we have a number of people furloughed and are looking to be able to have them return on a part-time basis. Will we still be able to put them on and off furlough? Maybe 2 weeks on furlough and then 2 weeks in work, 2 weeks on furlough, etc. The answer to that is yes, absolutely you can. You are permitted to put in place whatever arrangement you want to. And in fact, if you think about what I've just said in terms of the calculations, it might be better to do it that way and easier for you to do your calculations if you're rotating people in blocks. It also might be fairer for the staff as well. Second question, can Sally advise if the changes to the working time regulations around annual leave, that 4 weeks that can be carried over for 2 years and 1.6 weeks for 1 year, apply to the 19-20 leave year? Okay, so let's just be clear. The current leave year is the leave year that's being affected by COVID. The carryover of holiday is to the next 2 leave years. So obviously anything that's not been able to be taken during this leave year can be carried over to the next 2 leave years. And everybody's leave year may well be different. It doesn't have to be the calendar year. What carries over is the 4 weeks. So up to 4 weeks can be carried over. That's the entitlement under the Working Time Directive in terms of annual leave. Now, in the question, you've made reference to the 1.6 weeks being carried over for 1 year. There's no provision, because the 1.6 weeks is a domestic entitlement. It's a UK entitlement that's not provided for under the working time regulations. There's no provision for the 1.6 to be carried over for 1 year or indeed 2 years. It just isn't dealt with. The only thing that's dealt with under the new regime, which is the coronavirus amendment, working time coronavirus amendment regulations, is that the 4 weeks can be carried over to those 2 leave years. That means you can either give notice to require your employees to take the 1.6 days during this holiday year, or if you wanted to, you can agree for them to carry it over. But that's up to you to agree with your staff rather than it being anything that's required under the new legislation. The second question around that is also, as the 4 weeks are related to the EU rules, I think, is anything around this and being able to carry it over likely to change now that we're exiting the EU? No. The simple answer to that is no, it won't be. And the reason being that although that holiday is provided for under EU legislation, the Corona amendment regulations to deal with this holiday pay was introduced by UK government. So it's a UK government change to the legislation, obviously for the emergency situation that we're in, and it will not change whether it's Brexit or not. I think that deals with all of the questions that I had in advance of today, but have we got any more questions? I hope everybody hasn't fallen asleep with all of those calculations.
Thanks, Sally. We have got a few questions in the chat box. Just before I get started, anyone who joined late, to ask a question, it's at the rail at the bottom, just on the icon chat, and you get a chat box. If you'd like to ask a question to Sally, then please do that way, and we're just going to go through them now. So I've got one that was sent to me privately, but would like to ask you the question. Can you please ask Sally what happens if the part-time arrangement equals the 20% top-up? Do I still need to do the calculations this way?
Sorry, just repeat that again.
What happens if the part-time arrangement equals the 20% top-up? Do I still need to do the calculations this way?
Yes, that's my understanding.
Okay. Next question. When the employer is required to top up, can the employer ask the employee to work the equivalent hours of that top up?
Yes, if they wanted to, because obviously they're paying them for those hours. So they could say, well, you'll be furloughed for the proportion that's not, and you're required to work for the top up proportion.
Perfect, thank you. Next question. Do we need to make any special arrangements for currently shielding employees to return to work, such as an occupational health report?
That might be a really good idea, especially if it's somebody that's clinically vulnerable. You've got to carry out a risk assessment anyway. My concern about the risk assessments is that they may have been done perhaps a few weeks ago, put on the shelf because this is what you do. We've assessed the workplace and this is what we're going to now do. The workplace will be changing as we go forward. You'll have more people coming back into work. You might have different people doing work that they weren't doing previously. You've got vulnerable people coming back into the workplace potentially. So all that needs to be risk assessed. And absolutely, if you want to do belt and braces and an occupational health review, then yeah, I think that's a good idea.
Okay, thank you. Next one is, where is the government guidance which states we do not need written consent for the new Flexible Furlough Scheme? Have seen conflicting views but can't find it on the government website.
There's nothing on the government website. If you recall previously, we all panicked because we started furloughing everybody. And at that point, nobody got anything in as by way of consent. It was simply notification was given to the employee that they were being furloughed. The whole country went into panic, thinking that their claims weren't going to be accepted because they hadn't actually got the consent of the employee. And therefore, it was then clarified under the old furlough scheme that actually it wasn't necessary to get written consent as long as it was put in writing and the employee was notified of what the requirements were. So carrying that forward, there's no further guidance come out about that, but you continue as you did. For all those that have got the employees to just sign to say that they've received the letter, that will be absolutely fine.
Perfect, thank you. Next, can employees on maternity leave finish maternity leave earlier than originally planned without giving 8 weeks notice if the organisation agrees and be put on furlough, or do they need to wait until their original end of maternity leave date?
Okay, so this is a complex one because you could end up in a situation if you agree to allow the person to return early. And we remember early on in the guidance, they were suggesting that this was possible. Okay, they were saying, yeah, people can return from maternity leave early. That's not as straightforward as we think. If you were to say somebody's got to give 8 weeks notice to return, and you have notified the employee, as you should have done, either upon receipt of the MAP-B or shortly after, or prior to the employee or just after the employee going on maternity leave, what the end date for their maternity leave was. Let's say it's 52 weeks, and the employee wants to give less than 8 weeks to return, technically they're not entitled to, okay? If you've got a situation where you fail to comply with that by giving them written notification of the date for their return, then in all honesty, they could give less than 8 weeks notice and they can therefore return and be furloughed. I know it's complex, but if you can at all ensure that if you've complied with your requirements in giving notices, that the employee gives you 8 weeks notice to return and then they're furloughed, you'll probably protect yourself. Just know that if you're going to allow somebody to come back in that situation where they should be complying with the 8 weeks, there's a potential risk that you might not be able to recover. I'd hope that the government would take a really proactive stance on that and say, well, okay, we know that person's coming back from maternity leave, and under the new regime, anybody returning from maternity leave can be furloughed and therefore will accept the claim. But you need to know that there's a risk there, and I've not found anybody yet that's made that claim and got a no or got a yes, but actually we will want the money back. So just be aware of that potential risk.
Perfect, thank you. We've got about 5 questions to go. So the next one is, any tips for a simple system for logging part-time furlough hours worked? We're only a small charity, currently 5 people are on furlough.
I think it's up to you. It's whatever system you want to use. You could do an Excel spreadsheet. Are you talking about the actual mechanics of when the employee comes and the hours that they work and recording those hours, or is it actually just how you're going to keep your records?
Right. We'll just wait for Claire. Claire, if you can hear and just reply in.
Bit of both.
Bit of both.
Bit of both. Okay, so you should anyway, for your normal systems for people coming into work, have signing in and signing out. And if you don't, because normally you'd have them at least for fire safety and those sorts of reasons. You'll need to, if you haven't got something that's defined in place, make sure you have. So whether it's a book that everybody writes in, whether there's some sort of electronic fob that they use to get in, whatever the case is, make sure you've got that written down. And if it's in writing, then so be it. And likewise, if you're recording those hours in a way that you'd be able to send to HMRC, you can do it by a spreadsheet. Whatever works for your organisation, really, as long as you've got the record, whether it's a computer record, whether it's a written record, whether it's on their personnel file, or you keep it in a file on its own for HR purposes, that's absolutely fine.
Perfect, thank you. Next is, can a 3-week period in current furlough go over, say, 2 last weeks in June plus first week in July, and if so, how do you claim this? Okay,
so that's a really important question. If you've got anybody that is taking furlough after the 10th of June, and if we took it as today as an example, so if we use today as an example, I'm going to be furloughing somebody today. They, under the current scheme, have to be furloughed for 3 weeks. So although the new scheme starts on the 1st of July, they will have to be furloughed now for a full 3 weeks, which will take them into July in terms of their fixed 3-week period. Once they've completed that 3-week period, they can then take part in the scheme. So for example, if we waited until the 27th of June and somebody was furloughed, they'd have to do the full 3 weeks under the current scheme, and then they could be part-time furloughed after that. So it means that there could be a period in July where they're fully furloughed for the 3-week period. Once that's been exhausted, they can then go on to the part-time scheme. Does that answer that?
I hope so. I'll let Dawn reply, but Dawn, does that answer your question? I'm going to go with a yes for the. Oh, sorry. Dawn's just asked one more question. How do you claim over 2 periods?
Well, you're going to, although we've got that situation where you're doing the part-time leave, everything's got to be done in that month, unless it's for a few days at the end or beginning of each month. With that claim, you are going to have to, I mean, I don't know how you do the mechanics of it online, but you are going to have to claim for that full 3-week period, even though it goes over into July.
Okay.
And remember, that claim will need to be done before the 31st of July, otherwise you'll lose the right to make that claim.
Okay, I hope that answers your question, Dawn. If you could just say yes or no, and then we can move on. Oh, thank you. Okay. Next question is, could you restate how many days holiday the company can request a previously furloughed employee to take this year?
So when's the holiday year from?
Julie, if you could just pop your answer in the chat. (2020 January). Yeah.
Okay, so you've got an employee who is subject to a holiday year from January through to December. Let's say they've been furloughed from March all the way through to, April all the way through to now, and they haven't taken any holiday. You could, if you wanted to, give them notice under the Working Time Directive to take the majority of their holiday this year if you wanted to do so. So there's nothing, even though the legislation says that an employee can carry over that 4 weeks holiday, so it's 4 weeks, it's the Working Time Directive entitlement, not the additional 1.6 which the UK gives us. If it's the case that you want the employee to take that holiday and not carry it over, you need to give them double the amount of notice of the amount of holiday to be taken. So if it's a week, you've got to give them 2 weeks notice. However, if it's the case that you're not going to require those employees to take that holiday by December, they've got the right to carry over the 4 weeks, but not necessarily the 1.6. So in my view, you can either agree to let them carry the 1.6 over 2, or you can give them notice to take the 1.6 weeks in this period through to December. The bonus, of course, of getting employees to take holiday now is that some of their pay, of course, will be met by the furlough scheme. So it's really an incentive for you to clear out holiday. We all know that a lot of people are having a really nice time at home, even though they can't get on a plane or perhaps drive down to the coast. There's still an opportunity to have lots of staycation days. So you've got to think about how reasonable it is to require the employee to take holiday, but the weather's been glorious and we know lots of people have enjoyed days, you know, around in the parks and all that sort of stuff. So there is an opportunity for people to take their holiday.
Okay, thank you. Next is, can we ask employees to take holiday whilst on furlough?
Yes.
Okay.
Double the amount of notice needs to be given.
Perfect. Okay. Next question is, going back to the question about asking employees to work hours equal to the amount you are topping up, are we talking about the 10 or 20% top up to 80% of wages, or only if we are topping up by 20% to 100%, or both?
Both, effectively, both. There's ultimately, if you say, for example, we're topping up the 20%, and you said you're going to be furloughed for the 80, but we want you to come back to work for the additional 20, there's no problem with that. If you were to say to an employee in October, we're only getting 60% from the government, so you'll be furloughed for 60%, but we want you to come to work for 40% on the basis you're still topping up the extra, then there's no problem with that.
Okay, fab, thank you. Next is, we are owned by an American company and they are adamant that we do not need to do a risk assessment. They are only asking employees to sign if they have a symptom or being in contact with someone who is infected. What is the UK law?
I think you need to tell the parent company to have a little look at the Health and Safety Executive website and the obligations on employers to provide a safe working environment. The HSE website, if anybody hasn't looked at it, it's got some really good templates on there for COVID-19 risk assessments. You will be obliged absolutely 100% to do a risk assessment. So let's put it into perspective, and it might be helpful for you to go back to those that are questioning this to say the biggest issue we will have is if somebody contracts COVID in the workplace and they prove that we were negligent in not providing that safe working environment and we haven't done a risk assessment, then you're going to be in a real lot of trouble in terms of a personal injury claim arising from that employee. It's absolutely imperative that a risk assessment is carried out and that they're regularly reviewed, and of course that they may be different across the company. There could be, you know, have a different risk assessment for the offices compared to the shop floor, you know, whatever the case may be, but every part of the working business should have a risk assessment associated with it.
Okay, thank you. Next is, I have claimed 80% of the monthly salary, not based it on hours. Is this okay?
I don't know, and I don't think so. I'm going to say I don't think so because obviously I haven't written the guidance, but if you look at those calculations on the government website, those suggest that that's the correct way to do it. And I think going forward, there will be more of an assessment in terms of how these calculations are undertaken to avoid, and we would all do the right thing, but to avoid people claiming for hours when actually people are working. I think it was easier when people were fully furloughed, but now there's going to be this kind of like arrangement where some people are working and then they're furloughed. It's a bit more open to fraud and people claiming for hours that they shouldn't be. So I think just have a look at the guidance and see whether or not that would work. I mean, it may be that with that current calculation, your claims have been being paid and there's no issue, but I just suggest you have a look at that guidance in terms of going forward.
Okay, great. Next one, with regard to takeover of holiday, our staff can easily take holiday as their job is not stopping them from taking it, but we feel people are holding back and hoping to take all 20 days over. Is there any way we can stop this? We've sent emails encouraging them to take it.
Just give them notice. So if you're in a situation where you want them to take 2 weeks leave, you've got to give them 4 weeks notice of when that leave will be taken. And you have the right to do that under the Working Time Directive. Outside of COVID, all employers have always had that right under the Working Time Directive. So you can implement that to give notice to the employees. Obviously, you want to be able to get, when employees do come back to the workplace, to have as many people with you as possible to get the business going. The last thing you're going to need is lots of people trying to take lots of holiday at that particular time. Also, as I've said, if they're taking it during furlough, you've got the government top up, obviously through the scheme, to cover some of their holiday. If they are taking holiday, remember it's 100% pay for any holiday days taken, but you can claim obviously the percentage through the CJRS scheme.
Perfect, thank you. Just the last few questions now, I think. If anyone else wants to ask a question, if you could write it up now, and we'll get to it after these ones. So next is training consultants working in different premises, doctors' surgeries up and down the country. I can't risk assess all premises. Would hope most practices are okay, but not sure hope is sufficient. They are going to be working from home initially, but when they return, how do I risk assess this?
Okay, well you have a look at the templates in terms of how you can carry out that risk assessment, but it might be just worthwhile speaking to the practices that they're going to be visiting and asking them what risk assessments they've done. No one's going to criticise you for doing that. In fact, it's a good thing to do because it shows your employees that you're taking seriously what other premises they're going into. Likewise, let's say, for example, delivery drivers or visitors were coming into your workplace. It is the case that they're likely to say, well, we want to know what measures you've taken before we send people in. Now, for those, the government's encouraging for those companies that have got more than 50 employees to actually start putting on their websites their risk assessments. So that shows how the government are looking at what companies should be doing to reassure people that are coming into their workplaces that you're all doing what you should be. The simple answer is, I suggest you ask the practices for confirmation of what risk assessments they've done and what measures they've put in place, because then you can't be criticised for not trying to protect your staff that are going into those premises.
Perfect. Next question is, we have asked employees to sacrifice half a day holiday a week as we are topping up their salaries to 100%. Can we continue to do this and ask them to come back part-time?
Well, you won't be able to get them to come back and work the hours that you're saying you're paying as holiday, because otherwise they're not actually taking the holiday. So no, I think the answer to that is no. If you're expecting them to come and work the part-time hours for the hours that you're paying them for the holiday, then no, I don't think you can do that.
Okay, and I think this is the last question now. So, if staff have been made redundant, how long can they be kept on furlough for?
So if they've been made redundant, are they still working for you, or are these people that you've brought back because of the scheme? So you made them redundant and then you've brought them back and furloughed them. Is that what the question is? Just to double check.
Dave, if you could just write your answer in the text box. No, on furlough, but won't be able to continue employment.
Okay, so I think Dave, what you're saying is that you're going to have to make some redundancies potentially, and you're wanting to know therefore whether you can continue to furlough them or whether they should be made redundant now. Is that correct?
Yes, potentially. Only provisional at the moment.
Yeah. So you could, if you wanted to, and I'm advising clients this, you can take advantage of the scheme for as long as you want to. So if you wanted to, you could take advantage of the scheme until the end of July without any, obviously, cost complications for yourself. If you then move forward into August, September and October, if you wanted to continue to furlough those people, there'd be the contributions that would need to be paid. And at any time up to that date, you could proceed with redundancies if you needed to, or you could wait until the end of the scheme and then proceed with the redundancies. But there's nothing to stop you from doing that now, or working towards the end of July before it becomes a cost issue for you to make those redundancies.
Perfect. We've just had another question. Our offices are in a shared building. They have done a risk assessment, but do we also need to do one?
Yes, you do.
Okay.
Just so that you've got your own legal confirmation of what assessments you've done.
Perfect. I think that's it. If anyone has any questions, last call, if you could just write them in the box, and we'll do them just before we finish. I'll give everyone just 2 moments, or if it is easier, please unmute yourself and ask a question. But I think that's pretty much it. Just
if not, yes, people can always send questions to you after, and
yeah.
I can deal with them. I can deal with them separately and email people.
Perfect. Okay, that's great. Well, I'd just like to say thank you, Sally. I hope everyone found that useful. As always, we've got some really, really nice comments in the box. So thank you again for taking the time to come and speak to us today. Like Sally said, if anyone does have any further questions, please feel free to send them to me, and I'll send them to Sally, and she will answer them and get back to you. Some really, really nice comments in the box. So thanks everyone. Just before we go, I'd just like to mention a few upcoming HR focused webinars. So the first one is on Monday 12 till 1, and that's preventing and managing COVID-19 outbreaks in the workplace, and that's delivered by the NHS. Wednesday 3 till 4 is an introduction to risk assessment and COVID-19. And then Thursday the 2nd of July 3 till 4 is flexible working requests and equal opportunities, and again that's with Sally. All of our webinars are free for members and non-members, so if you think anyone you know would benefit from these, do spread the word, and I'm happy to book you all on. But I think that's it. Thank you so much, Sally, again, and thank you everyone for joining us. I hope you have a wonderful rest of the day, and take care everyone. Bye bye.